We hit our big stories. A showdown is expected in the Legislative House this week as the NDC, I don't know whether to say minority, but the NDC vows to jealously guard its new status in Parliament as the majority, owing to a decision by Speaker Alban Bagbin to declare 4 seats vacant, setting Parliament and the judiciary on some sort of collision course days after the Supreme Court placed a stay of execution on the decision by the Speaker of Parliament to activate, we know it, Article 97, 1G, and if you want to extend it, H of the Constitution to declare the 4 seats vacant. The question, how do we navigate this legal gridlock and constitutional conundrum with its far-reaching ramifications for the governance of this fledgling democracy? And yes, if you want to compare our democracy to others, we're still a fledgling democracy. We unpack the issues this morning with our guests joining us in the studio. We have Amanda Clinton, she's a lawyer. We also have Kweku Painto, he's also a lawyer. And I always say my special guest, Sweetie Abochi, yet to be a lawyer.
Sure.
So I'm forecasting, I'm looking into the future.
Well,
so
let's
we
see
have
how that goes.
An all-lawyer panel.
Oh, wow. Yeah, and you are students of law. So, yeah, I'll be steering the conversation for you as citizens while they do the legal part. But Kweku Asante, our parliamentary affairs correspondent, was in Parliament throughout the entire proceedings and filed this report. We take a look and then we come back in the studio to discuss.
On Thursday, Speaker of Parliament Alban Bagbin delivered a ruling, or what some have said was a declaration, that effectively made the NDC group in Parliament the majority caucus in the House. But 24 hours after that, the Supreme Court ruled to stay the execution of that ruling by the Speaker of Parliament. The NDC MPs, however, say that the Speaker of Parliament did no wrong and they will resist any plan to push them back into the minority.
For the avoidance of doubt, the Speaker's decisions to declare the 4 seat vacant is lawful exercise of his responsibilities derived from the 1992 Constitution and the Standing Orders of Parliament. The effect of the Speaker's declaration is that currently we no longer have an independent member of Parliament. The MPP has 135 members of Parliament only. The NDC has 136 members of Parliament, and there is no second Deputy Speaker of Parliament. We will jealously protect our new majority status and will not bow, retreat, nor surrender our lawfully earned status.
Dr. Cassia Latofosen, who is the NDC leader in Parliament, has been announcing the plans that the NDC group have if they stay in the majority, including to repeal the e-levy and the betting tax.
It is indeed true that we will use our new majority numbers to benefit Ghanaians by introducing private members' bill to remove the e-levy and to reduce the suffering of the people of Ghana. Yes. It is also true that we will use our new majority to remove the betting tax and other nuisance taxes. Yes. We stand with him, pledge our support, and urge him to protect the dignity and sanctity of the Parliament of Ghana. In the same vein, we call on Ghanaians to stand by the Speaker and resist oppressors' rule. From day one, we have not reneged on our fight for the people of Ghana.
When asked specifically about this Supreme Court ruling, Mahama Yariga, the NDC MP for Boku Central, says, until and unless the Speaker of Parliament comes to the floor and informs them that that is the new course of action, they will still consider themselves as the majority.
We are not aware of any law or any constitutional provision that enables anybody to suspend a decision of the Speaker in Parliament properly constituted. Be that as it may, we as parliamentarians act on the basis of communication coming to us from the Speaker. We don't hear things in the news and act on them, or cite copies of records of proceedings in any court on social media and act on them. We act on the basis of communication coming to us from the Right Honorable Speaker And if that communication says we should walk into the sea, we walk into the sea. Because we listen only to the speaker and nobody else in relation to the integrity, the legality, and the appropriateness of what has happened in the chamber of Parliament.
On Tuesday, the House is set to resume after it adjourned last Thursday, and it's going to be a showdown because both sides are now carrying themselves as the majority in Parliament. But of course, the majority can't only be one side, and it is only one side that can sit on the right-hand side of the Speaker. But with both the NDC and the NPP pushing themselves onto that right side, it is left to be seen what exactly is going to happen then, with even claims now from the NDC MPs that certain soldiers are set to be deployed to the precincts of Parliament on Tuesday when the House resumes. Reporting for Joy News, Kweku Asante, Parliament House, Accra.
So there you have it, and we have our lawyers in the studio. It's a great panel today to help us discuss this surgically, like Benjamin would like to say. But let's first start with your quick thoughts or reflections on all of this. There are about 4 issues at play here. The Speaker's authorities come in question, judicial oversight, impact on governance, and what the shift in democracy means for our balance of power. Let me start with you, Amanda. Where do you sit in all of this?
I think that parliamentary privilege means that the internal matters of Parliament are beyond the purviews of the courts. And it's clearly stated, Article 115, that there shall be freedom of speech, debate and proceedings in Parliament, and that freedom shall not be impeached or questioned in any court or place out of Parliament. Furthermore, that even for the Speaker to appear before the court or any member to appear, the Speaker has to write their consent. So it's only with that consent. So very much I think this is going to be an impasse in terms of, you know, the Supreme Court has asserted their power, and should the Speaker not adhere, then they might cite him in contempt, and he similarly can cite any member of the judiciary, including the Supreme Court and everyone under Article 122, and he can hold any member of the judiciary in contempt. So it's going to be an impasse for sure. And I do think that NDC should hold on to this majority. And I'm being impartial here, but only because of what took place in 2020, where there was that one vote for Formosa vote that meant that the NPP were the majority. And so NDC had to yield to that decision, despite the fact that they didn't like it very much. Okay. And so they're following precedent, they're following the standing orders, and they're following the Constitution. So I think they should hold, basically.
An impasse. Mr. Pencil.
I fundamentally disagree with my learned friend over just about everything she said. We practice a constitutional democracy that's got 3 arms of government. And each of them is separate with specific constitutional duties or obligations. And they are separate. And it is only the Supreme Court that's got the power and the authority to pronounce on the Constitution in terms of its enforcement and everything that goes with it. And particularly, any part of the Constitution which requires an interpretation has to be done by the Supreme Court. Now, what has happened in this case is that we've got a Parliament that purports to put a meaning and interpretation on a part of the Constitution dealing with the vacancy of a parliamentary seat. Now, when you go to Article 99(1), that power to declare a parliamentary seat vacant is reserved only for the High Court of the Republic of Ghana. So in the light only, I mean, I've got a lot of reasons, but in the light only of Article 99(1) of the 1992 Constitution, Parliament cannot set it up to say that they are declaring somebody a non-parliamentarian, when that duty has specifically been reserved for the High Court of the Republic of Ghana. Besides, like I've said, the issue at stake now is the interpretation that is being put upon Sections G and H of Article 97.
Yeah.
It's an interpretation because the meaning does not come out. I have a different meaning. Other people have different meanings. Now, as it is now, we've got a parliament that is equally divided upon what interpretation ought to be placed on those two sections of the Constitution.
So you think we should seek to the Supreme Court to
Naturally.
clarify?
I do agree with my learned colleague and senior in terms of substantial constitutional interpretation requires hearings. The only difference in this situation, however, is that a stay of execution has been granted. And this is a fresh suit, and yet a stay of execution is ordinarily for, a court decision. And so with this stay of execution, it renders the court's final decision moot. And I say this because although the Attorney General, I think, made a claim for like 10 days, that his interim thing was only going to be for 10 days, the court decided that until they decide this final matter, their decision stands. But by the time the matter goes, they finally decide, it will probably be the election time. And so all seats will be rearranged, which makes the matter before them moot. Do you see what I mean? So this is why we avoid using things like stay of executions for substantial constitutional interpretations. And should this precedent now be set, every future executive can do such a thing, which in turn undermines, the rule of law, separation of powers, which is why they should all be separated in the first place.
Ben.
Mr. Paintel,
yes.
A few thoughts.
Yeah.
So you say, and I was listening to your words, purports to put a meaning.
Sure, you're
right?
Yes.
Do you think what the Speaker did was a ruling? I mean, I just want a quick thought on that. There's been a banter, the NDC, the MPP, that it was a ruling he delivered. Do you think that was a ruling? That was
whatever
an order?
it is, a form of verdict, call it whatever, a verdict, judgment, ruling, decision, whatever it is, the meaning of it is not lost on Ghanaians, which is that he had declared a certain state of affairs, which in his view ought to be ruling, which ought to be the case for us as a country, yes.
Right. So you say it purports to put a meaning on what should happen, but Parliament has, so to speak, already established this meaning. On the face of the law, I have a simple understanding that this means that once you cross carpet, and we know of the history of this from the Nkrumah era, once you trigger certain actions, there will be likely reactions based on whether you are independent and now you've decided to move to this side. In fact, this morning, Naya Jantwa was even suggesting that it shouldn't even be with the numbers we have. There's no majority, there's no minority, because there was 137 apiece with that extra person being the second deputy speaker, the Fomena MP. So it should have remained technically like that. I was trying to explain to her that there must be some majority minority for government business to run. But on the back of this precedent that was set in 2020 with Speaker Michael Quay, and with the fact that I don't know whether the accusation then would be that, because the other side then didn't contest it, so it had to go. Because I felt logically it flowed that in similar situations, there would be, though this is not a court of law, there would be that precedent applied. So then where does this leave us? Because in responding to Afenyo Markin's request, this injunction has been granted, but the substance of what Afenyo Markin took to the court has not been dealt with yet. Do you get what I mean? Where does this leave us in terms of the meaning and everything? People are saying 10 days. Now they are saying we'll go on till the court rules, which, like she's saying, could be only God knows when the court rules. I mean, where does that leave all of us?
Yeah, I agree with you, everything that you've said. But the point of the matter is that at every point in time, there must be some certainty, there must be some understanding, there must be some agreement as to, because like you said, talking about what you call the speaker rule, the speaker's ruling is clear, it's beyond a shadow of doubt. I dispute the fundamental basis of the speaker's rule on the basis of the very articles that we have referred to.
97, 1G and H.
That is so. Number two, as you have rightly said, the Speaker Okoye made a ruling. Even the facts of that case are not on the same force as this one. In other words, if my understanding is right, you may correct me if I'm right. In that case, that MP purported, or rather resigned from the party, or the party dismissed him, whichever is. The party dismissed him, and on the basis of that dismissal, now gave notice to the Speaker that this man is no longer a member of our party. The interesting scenario we have here is that all these 4 MPs who have a right to resign, they've not resigned. Number 2, each of these parties has a right to dismiss them. They have not dismissed. If any of these 2 actions were taken, that would put finality to this issue. So now we have the situation where these people, for all purposes, are parliamentarians, which differs significantly from the situation that you have described. But beyond and besides, Parliament can agree, once they are there, to agree to any way they want to go on with their business. But as long as any decision that they take affects anybody's right, in other words, way back the time that Michael Quay took that decision, anybody could have gone to court to check the interpretation of it. So therefore, we cannot be held. That cannot be a precedent that will hold all Ghanaians. Meaning, you know, when the gentleman was speaking, his case is that even if he said we should go and run into the sea, I think he said something to that effect. They will do it as long as it comes to the Speaker. It cannot be so as a matter of law. It does not mean that the Speaker can virtually turn himself into a judge of the Supreme Court or the Supreme Court itself now to give interpretation that will bind not only Parliament but Ghanaians. Because don't forget that these people, these parliamentarians, they have a constituency. They have a people who put them there.
Yeah,
and the people who have a right.
There, if you look at Honorable Isiama, for example, he went as an independent candidate.
Yes.
And people would often say that, oh, is he representing the interests of the people? He decided to caucus with the MPP once he got into Parliament, right? But if he's now going, he's leaving his independent candidacy. And the people voted for him because he was independent, because they wanted him, not the MPP candidate. Is he then representing the interests of the people who voted for him?
The difference is that when you become a parliamentarian, you are not a parliamentarian for only the people who voted you into office.
I get that point.
And of course, if he's there, we don't know what he has with his own people. But it is for his people, whether the people who voted for him, who nobody knows, or for the constituency to make a decision with regard to the fact that we went there as an independent and subsequently decided to caucus with the MPP. It is for the constituents to take, to take a decision on how to deal with their parliamentarian. But what is happening here now is that somebody sitting in Parliament decides that your parliamentarian that is here has taken this decision, which in our view, but let me go to my fundamental objection to what is going on now, that these parliamentarians who are there, I want to do with analogous reasoning. It's part of interpretation of the law that you do analogous reasoning. 2 examples that readily comes to mind. First, contract of employment. In a contract of employment, there is an opportunity for a person to leave the job subject to giving notice. When you give notice, 1 month, 2 months, 3 months, whatever it is, at all material time during the period of the notice, you are still an employee. Nobody is going to say that because you are given this intention to resign from this job, you are no longer an employee. So what these people have done, against the backdrop of an election which is about 2 months away, is to give notice that, let me tell you, that in this 2 months' time, 3 months from hence, if I win the election, I do not intend to be part of you.
I do agree with my senior that this is sort of fact-finding in terms of the Speaker came to a decision based on facts, etc. But since all of us sitting here are lawyers and, you know, soon-to-be lawyers, etc., the plain meaning of Article 97G includes the words to join another party or seeks to remain in Parliament as an independent member. So if you are not NDC and you are not NPP and you are running for president, I think it is expressly stated that you are independent. Furthermore, come what may tomorrow, when I think they resume, etc., should the Supreme Court exercise their right to hold the Speaker in contempt, you know, the Speaker can likewise hold any member of that panel, including all of them, and the Chief Justice in contempt under Article 122, which emphasizes that acts or omissions amounting to interference with parliamentary proceedings can be treated as contempt in Parliament, particularly because this is following established practices in Parliament. So we can all, you know, differ in our opinions. So the bottom line is this is an impasse. Because, you know, once the Supreme Court has triggered this, should they further trigger it with contempt proceedings, you know, he can likewise, you know, trigger contempt proceedings. And we have the longest democracy on the continent of Africa. So I think all parties should think very long and hard about what transpires tomorrow and what other forces will be available.
Just for clarity, before you come in, Ben, please, let me do this. So you yourself just said that these people have not resigned. Naturally, the interpretation that you just gave from Article 97, Clause 1G and the rest says it mandates MPs to vacate their seats if they leave their party or choose to run as independent candidates. And they had declared that intention, yet they didn't take the step to resign. The Speaker of Parliament is the leader of Parliament. The Supreme Court cannot tell Parliament how to do their business. So who does it fall to see to it that this Article 97, Clause 1G and H is implemented to ensure that these 4 people who've declared their intention to run as independent candidates or leave their parties, who does it fall to ensure that this is actually done?
See, my basic point is that a declaration of intent does not amount to actualizing the intent. In other words, they've given notice. And like the example that I gave to you about the employment contract. If you give notice to Joy FM...
But it's not the same, is it?
No, but I'm talking about analogous reasoning.
Okay.
If you give notice to Joy FM that in 2 months' time you don't want to be working here, it does not mean you've left. In a marriage, I mean, I'm giving you another example. In a contract of marriage, the law is clear that it is only a court of law that can pronounce on the dissolution of a marriage. And however long a matter stays in court, the marriage is not dissolved until a court of law has made a pronouncement on the issue.
Right.
And therefore, it is not a disagreement, it's not a confusion, it's not a trouble that is in a marriage, but it is what the court of law ought to do before you can say that the marriage has been dissolved.
And yet he's the king of his house. You see what I mean? We have to understand that the Speaker, this is his domain. He's the king of the house, so he was merely informing them about vacancies available. So where does the buck stop in terms of who is to decide whether, on the facts, the vacancy is available? He took that decision because he has the authority and the power as vested in the Constitution. And so thereafter, it is not for another arm of government, hence the term separation of powers, so there is not this sort of imbalance sort of thing. So, I mean, we can argue it from a legal perspective, etc., but the bottom line is this is where power lies. And if one arm decides to exercise power, the other arm will surely respond, which could leave Ghana in quite a situation.
I want lovely Amanda, please, if you don't mind, I want lovely Amanda to place what she has said within the context of Article 99 of the Constitution, which expressly states that a member of Parliament can only leave his seat upon a pronouncement of the High Court. I mean, how do you place it?
I mean, I don't know whether Article 99, we keep talking about, it's not as though the courts were the only ones that would be able to determine parliamentary work. You know, it reminds me of the, the academic immunity that lecturers enjoy. Once they are within those precincts, whatever they say, you can't come out and say, because I said this, you're going to arrest me. They have that immunity. But
Article 110 as well says that Parliament has the full authority to regulate its internal proceedings and procedures as stipulated in Article 110, in essence. And to 4, an Attorney General says that the Supreme Court underscored the need to respect the boundaries of the different arms of government, cautioning against judicial overreach into legislative affairs.
So I think we are engaging in some things that may affect the separation of powers in our country and what shape or form it takes. For example, recently, when the president refused to sign certain bills, LGBTQ and the rest, who was to fetter him? We had certain processes run. The law is clear on what the president should do.
You're very right.
You either sign or you give your certain reasons, and then the matter proceeds from there. He didn't do either, did he?
Yeah, but
let me make my point. The point is, we are setting very dangerous precedents.
That is so.
When it comes to the 3 arms of government. And once you have interfighting, quarreling, is going to be problematic going forward. Some things must be clear in our minds, precedent-wise and technically what the law stipulates, so that you don't have a confusion of who thinks he or she is supposed to do what. And that is where we are. We're on the precipice. Now, these individuals ordinarily may have had to communicate to the Speaker that, for example, Honorable Esiama, I am independent, but I am going to contest on the ticket of the MPP. And I think Sweetie posed part of the question I was going to pose. In the absence of that, if they were not going to act of their own accord, I mean, Fee Central and others, that, okay, so I'm going independent, I'm no longer representing the party. Who was to determine, who was to say that on the face of 97(1)(g) and H, this is what the law says. So technically, this and that. They were not taking the initiative. They were obviously not going to move. They were going to enjoy the rest of their tenure, sit in there, do what they felt they had to, and then come 2025, whichever person has won or lost would then see where the cookie crumbles. I don't think that also logically is what the law is telling us to do. So looking at it from this angle, and respectfully, the bit about an employment contract, you see, there are contracts that will also tell you, and it depends on what contract you are signing.
You're right.
If you decide to sign a certain contract, you are bound by it, and that's your problem. But most of these contracts will tell you that you give notice. Others will also tell you that you can leave immediately, but then you forfeit whether your full salary for that month or a certain portion of that salary. So I think it's a dicey bit. On the bit about contempt, where it could get really nasty. Oh, you call me in contempt of the court. I say you are in contempt of my parliamentary decision, ruling, order, whatever you want to call it. I don't know, but I want us to focus there. How could this degenerate? Amanda, and to Kweku as well.
It's going to be a free-fall. You know, I mean, literally, if the Supreme Court holds him in contempt, he, by the Constitution, can hold every single member of them in contempt and the Chief Justice and bring them before him and say, you're interfering. So if the Supreme Court is the highest court of the land, and if the separation of powers means this is exactly why everybody should stay in their lane, and you have somehow done this, that is the issue. And the other major issue is this stay of execution on a fresh suit. You know, a stay of execution is on a court decision, etc. So it sets a bad precedent as well, because should this hold, every future president coming in can just do stays of executions until they get what they want. Because, I mean, at the end of the day, the stay of execution is going to last until we imagine the elections, and then the seats will be chosen anyway, so it will be a moot point before the court. And so we are all academic, we are all understanding what the inference is here. But beyond the inference is the fact that it might cost Ghana losing this long democracy we've had, etc. And so, you know, everybody will exercise their power tomorrow. Perhaps, but we should think about it long and hard, because the legislative arm is just as powerful as the judicial arm, basically.
Mr. Pinson.
You see, there's an impression that anytime anybody comes into conflict with the law, the natural consequences are the person of contempt. We are too advanced in democratic governance to resort to those basic norms. There's a classic case of Lord Denning. Is the most celebrated judge in the Commonwealth. Somebody throwing an egg at him in court, and he ruling that he refuses to hold the person in contempt, because that's exactly what the person wanted to achieve. There are times that you know a certain course of action is being taken to achieve a certain end and whatever, and with due respect, you'll be acting not normally if you take that step. So I personally don't believe things may get worse. But nothing will happen in this country for Parliament. The people who sit in Parliament, don't forget that it's just a section of them, and the other section sits there. If they themselves decide that when the court rules and they find themselves uncomfortable with it, they will not comply with it. That is what Ghanaians will know. The next time, when I go to court and there's a judgment, there's a ruling, whatever it is, and I'm not happy with it, I'll have to take a cue from Parliament. So that is exactly the seed that we are all sowing in this country. I've never ever heard of a case where a parliament, the maker of the law, says that something affecting us has gone to court, and the court has taken a decision that we are not comfortable with, and for that reason, we will disobey the court. I wouldn't know what the effect, the impact, and the consequence of such a decision. That's what I find much regrettable. But
was there a decision before Afenyo-Markin went to court?
Please, you see, I'm careful not to go into that politics. But don't ever think that the courts are always right. They are never. There's a case that I keep on mentioning. I lost in the High Court, I lost in the Court of Appeal, lost in the Supreme Court. I lost even on review. And as I sit here, I'm not happy with the decision, all the decisions. But what do? That is the law. Procedure, because we're not here to discuss procedure and when they should have filed. Let's assume for the sake of a discussion that what Afenyo-Markin did was wrong, dead wrong. Nonetheless, the Supreme Court has taken a decision. The question is, the lawmakers of this country, the people who expect us to obey not only laws, but rules and everything, they, in their case, have decided that when it comes against us, it will never happen. Are you saying that the Speaker should have waited for the Supreme Court's ruling before declaring No. I mean to say, the decision they've taken consequent upon the ruling of the Supreme Court, that they will not comply with it. That's the most unfortunate thing that ever happened in our constitutional democracy since Nkrumah's time.
So should we look into the future and in terms of saying what we think is going to happen tomorrow? I mean, like, for instance, I think the Speaker is going to say those 4 seats are still vacant. He's not going to declare who is majority or not.
I mean, the NDC has already declared that.
Yes, so he's going to say, I'm just announcing that the 4 seats are still vacant. I doubt the Supreme Court will cite him in contempt because that will lead to a domino effect. And
which they could, by the way.
They have more than the right to cite him in contempt. But as you know, has been pointed out, they might not exercise that because they know that it would lead to this sort of impasse and this domino effect, which could leave everything open. But by the precedent set by Professor Michael Quay Senior in 2020, where expressly it's stated in the Constitution that this is when a seat is vacated. NDC, I mean, they spoke about it for days on the radio, and yet they had to yield to the leader of their house. And in the same manner, NPP will have to yield to the leader of their house. I mean, this is my take on this.
When we come back into the studio, we're going over the phone lines. When we come back, there's a part of the Constitution I want to bring because it reflects all 3 arms of government. Well, let's bring in Roxton Nelson Dafiamapo, the South Dai Legislator. He joins the conversation. Good morning, sir.
Good morning to your viewers. Good morning to my good people in South Dai and taking quality of the talk.
All right.
Good morning to my co-family.
Right. What is your take so far on the proceedings, your end in Parliament? Now it's become dicey, whether to say minority or majority. It's become a tricky business. Your end in Parliament, the NDC, you're saying that you are still the majority and that come Tuesday you're going to enforce your rights. Is that still your position?
Yes, that's our position, and that's the position in accordance with the Constitution. And let the point be made that Parliament is subject to the Constitution. The Supreme Court itself is also subject to the Constitution. Everything starts and ends with the Constitution. So whatever we are doing is subject to what the Constitution declares that we do. It is that simple.
The Supreme Court, the Apex Court, has not ruled on the substantive matters Afenyo-Markin sent to it, but it has stayed that decision, ruling, order, whatever you want to call it, of the Speaker of Parliament. Are you saying that you're going to defy the Apex Court, which has every right, though the Constitution talks about the High Court as far as members of Parliament, you're going to defy the Apex Court in terms of its interpretive jurisdiction?
Are you aware that the Supreme Court, in the form of office of Attorney General, is not reported yet, held just a couple of months ago, that the court cannot stay the hand of Parliament in the performance of this party? Is anybody aware of this decision?
Could you repeat that point?
In the form of office of Attorney General, the court said they cannot, under any circumstance, stay the hand of Parliament or injunct Parliament from the performance of its constitutionally mandated function. That's what the court told us. That's the law. I didn't distill that law. It was the Supreme Court that made that pronouncement.
So you're telling me
where I thought that against Parliament proceeding with completing the vetting of the ministers, the court said they cannot say Parliament has under any circumstance.
that is interesting. That
yes,
under no circumstance can the court injunct. Is it decisions, workings of Parliament? I'm not so clear. I'm just trying to find out.
Exactly. But let me make this point. And it appears that it's a point that nobody has affected his or her mind to. If Parliament doesn't work, if Parliament wants to listen to what the Supreme Court says in the ex parte decision, which is also erroneous constitutionally ab initio, because the court does not grant a stay of proceedings, stay of executing or injuncting activities case. If Parliament wants to listen to the Supreme Court, the Parliament cannot function.
Parliament cannot what?
Parliament cannot function. Parliament can't speak. That's what it means.
Okay, very quickly, Sweetie Abochi will be coming in with a set of questions as well. Very quickly, do you think this action of the Supreme Court is an act interfering in the work of Parliament? Is it interference?
It is beyond interference.
What would you call it?
It is beyond interference. And let me give you an instance. Parliament passed a bill into a law and sought to remit or transmit the bill to the office of the President in accordance with the constitutional provision for his assets. Somebody comes to court to say that the court should injunct Parliament from doing so. The court proceeds to hear the application and decides not to make pronouncement on after a heard application for injunction. So as we speak, there's an application for injunction against Parliament regarding the remittance of a bill to the office of the President. The court says that it's going to stay its ruling on the matter until the final determination of the case, or during the final determination of the case. It will make the pronouncement as well as the judgment of the matter. The effect is that Parliament appears to be injuncted in that process. If this is not a routine into the affairs of Parliament by the Supreme Court, I don't know what else it is.
Okay, Mr.
So, because as we speak, that bill has stayed in Parliament, is not been transmitted because the Supreme Court has refused to make a pronouncement in the interim on the merits of the application before it.
Mr. Devemeko, Parliament is an independent institution, right? The Supreme Court cannot tell Parliament how to... Hold on a second for me. The Supreme Court cannot tell Parliament how to do its business. However, it can tell Parliament if it's not doing its work constitutionally. The argument is that the Speaker was not supposed to declare those seats vacant. It's not within his power to do that. So should the judiciary not have the final say on how we steer this time?
That is not what we are saying. Whether or not Speaker has power to make those pronouncements as he may was a matter subject to Article 97. So if somebody is in court for the interpretation of Article 97, is the Supreme Court saying that Parliament cannot proceed to perform its functions until the final determination of the matter? Then Parliament will close. Parliament will shut up until the final determination of the matter. Because what Speaker has done, Speaker has already made the proposal. So Parliament will have...
In fact, Mr. Pencil here would argue that the Speaker of Parliament does not have the right to declare those seats vacant. Although the Constitution, the Article 97, Clause 1G says that these persons should vacate their seats, they themselves were not going to do that. And he argues that the Speaker did not have the right to actually declare those seats vacant. So in this confusion right now, is the Supreme Court not the last person to have a final say on how we steer this tide?
Thank you very much. The constitutional provision must be read in its totality. Now, find out who must inform the electoral commission whenever there is a vacant, when there is a vacant seat in Parliament. Find out under the Constitution whose duty it is. The electoral commission does not have public information or public information.
Roxanne, we are losing you briefly. Just move a little and start that point again so we can hear you better.
Sorry? Hello?
Better now. Go ahead.
I'm saying that under the Constitution, it is only the Speaker of Parliament that is mandated to inform the Electoral Commission whether or not a vacancy has been created in Parliament. Only the Speaker. The Electoral Commission cannot proceed to act and say that, oh, I have simply heard that an MP has resigned from office, or an MP has been diseased, or an MP has been elected as Speaker, and therefore I am proceeding to organize a by-election. The Electoral Commission does not do that. It has to be pursuant to a letter from the Speaker of Parliament to that effect. So it is the Speaker that, when you read the Constitution in its totality, the power to declare its vacant is inherent. Speaker for Speaker.
Right. Please hold. Mr. Pencil said he has some reflections on what you're saying.
See, my good friend, you cannot ignore the fact that whenever it comes to any confusion in the interpretation of our laws, it is the Supreme Court that's got the final say. What is happening now, in spite of all the authorities that you cited, you have to go to court. Even when the Supreme Court or any court has made definite, there's a precedent binding any situation that we find ourselves, before you go to court, you arm yourself with all the authorities, notwithstanding that only one person can always come up on top. Now, what is happening now is that you have given an interpretation to a section of the Constitution on the basis of which you believe your conduct is right, and your conduct is so right that even the Supreme Court must not have a say regarding your conduct.
I don't think that's the argument. I think that substantial constitutional interpretation takes hearings. And what is particularly peculiar in this situation is that there's been a stay of execution on a fresh suit. So it is to circumvent the process, suspend the Speaker's decision up until the point of the election where all seats are going to be rearranged anyway. So it's just a very intellectual way of getting an end result that circumvents justice and the procedure.
Yeah, but right,
so that is what people have.
Right or wrong,
right.
The Supreme Court has made a pronouncement of a sort. And the only issue, as I understand
a pronouncement which doesn't add anything to...
No, you call it that way.
Establishing what exactly we are hoping
for.
Is it right or wrong?
No, call it that way. Let's say, I've assumed for the sake of a discussion that the Supreme Court is dead wrong.
No, I'm not saying it is wrong. I'm saying that it has not established what the main point, the focal point is.
Yes.
Is this right? Is it wrong? They've just given an injunction.
That's the purpose of an injunctive relief. That's the usual purpose of injunctive relief, and they don't make a pronouncement on the merits. Now, the point I'm making is, must anybody who feels disaffected by that interim order that the Supreme Court has made take the law into his own hands merely because he is a parliamentarian? That's the issue we need to be answering.
But
nobody in this country has got the power to do what a section of the parliament is doing now.
No, but the legislative authority, where does it lie? Article 93(2) states that legislative authority solely lies in Parliament. The legislative power of Ghana shall be vested in Parliament and shall be exercised in accordance with the provisions of the Constitution. Article 110 further says that Parliament therefore has full authority to regulate its internal proceedings and procedures. And then what did the Speaker say? The Speaker said that the notice of polls confirmed the 4 MPs were running as independent candidates. They no longer had the mandate to remain in the current Parliament. So it was his duty to just simply announce the vacation of the seats. That was how simple everything was. But this stay of execution perhaps is the issue, because you don't have a stay of an execution on a fresh suit.
Yeah, but the point I'm making is that...
The point also to be made is that if you look at the Constitution, each of the arms of government has this to sort of delineate. If you go to 125.3, it says, the judicial power of Ghana shall be vested in the judiciary. Accordingly, neither the President nor Parliament nor any organ or agency of the President or Parliament shall have or be given final judicial power. Each of them have their own enclaves within which to work. And that's what some people are saying is an interference. If I may add Article 115 before you come in, Kweku Pencil. There shall be freedom of speech, debate and proceedings in Parliament, proceedings, everything in Parliament, and that freedom shall not be impeached or questioned in any court or place out of Parliament.
Any court.
The fundamental disagreement we have is that we know all these laws. Notwithstanding all that, the Supreme Court has made a definite pronouncement. The question now is whether any section of Ghana, be they parliamentarians, be they students, be they whoever, have the right to defy the order of the Supreme Court.
Yes, if they have parliamentary privilege, they do.
Excuse me. Parliamentary privilege to defy the Supreme Court because of the privilege or because of the point of law that arises on the basis of the distinction. Because talking about this issue of making a pronouncement as to whether somebody continues to be a member, it's not that of Parliament itself. It's a constitutional issue.
And yet the precedent was set by NPP.
Oh, please.
The precedent was set by NPP.
Okay.
Let's try to see whether we have Roxanne on the line.
Mr. Defa, are you still with us?
Some of these.
Okay.
Yeah. Okay, so one. Let me ask my senior Kweku, what the media law?
You're breaking up again.
Hello?
Yes, you're breaking up again. Reposition. We can hear you.
Hello? Yes. Hello?
Yes, go ahead.
Let me ask, what is the law? When is court?
Roxanne, we can't get your question. We'll try to reposition one last time. Else, you know what? We're going to call you with a different line because we need to hear what you're saying. So just end this. We'll call you shortly. But of course, that leaves us with this conundrum, this albatross round our necks. And only time will tell from tomorrow how this pans out. Like I said, the Constitution delineates clearly what the executive should do and cannot do, what the legislature should do or cannot do, and what the judiciary can or cannot do. Daphne Mekpo, can you hear me now?
Hello?
Roxanne, can you hear me now?
Yes, better.
All right,
now.
Go ahead. Much clearer. Go ahead with your point.
So my first point to my senior Kweku is that what is the remediable step available under law when a court decision is disobeyed? What is the steps available? That's contempt.
Oh, that's
is that not
okay, go on. I'm listening.
That is contempt. So we want to urge those who think that Parliament is disobeying the orders of the court to initiate the contempt proceeding. And of course, the applicant can do that. That's one. Number two, the order directed at Parliament is not directed at any group of people nor the Speaker. The Supreme Court is asking Parliament not to carry out its functions, its certain functions. That's what the Supreme Court is saying. It is not directed at any particular officer. It is directed at the organ of government, which is Parliament of the Republic of Ghana. So let nobody say that a group of people have decided not to respect the orders of the court. This matter is about Parliament as an institution. So that is what we are saying. We are saying that Parliament will have to shut down if the Supreme Court order will have to be obeyed. So me, I am in favor that we shut down until the matter is finally decided.
So you're in favor of what before the matter is finally decided?
Parliament shut down. Parliament tomorrow, Speaker adjourns sine die until the Supreme Court determines the matter.
Okay, so you're saying that then you're basically saying the strategy of your end in Parliament is that Parliament is going to adjourn sine die indefinitely at some point till the Supreme Court has also given its decision.
That's the only way to satisfy the Supreme Court in this matter, because the order is neither directed at the Speaker, at the clerk to Parliament, nor the members of Parliament. It is directed to Parliament as an organ of state, and as an organ of state, if the Supreme Court says, "Say, don't proceed with a certain function of office," you shut down, you go home.
What is interesting is that the Afenyo Markin suit was directed at both the Speaker and the AG, but the ruling of the court was general, like you make it. But what does this do? What does this do for government business?
Those are the inconsistencies I have identified. For instance, the Supreme Court said that the defendant was absent when clearly what was before them was an ex parte application. So how do you expect the defendant to be present in court?
Exactly. So the point then is, do you realize what this does for government business? It means government business is coming to a grinding halt.
Yes, because the court says that they don't want government business to suffer. And yet what they are doing is to shut down government business. That is what they have done.
Okay, so now we have a fair idea.
The court doesn't appear to appreciate how Parliament functions. With all due respect. And they've done it on several occasions in respect of several matters that have gone before the court.
Mention one other occasion.
The court, for instance, said that a certain provision in a bill was not debated long enough. So the same court shut it down. Parliament had to go back to go and re-debate that matter. Which cost us resources and time.
I see. I don't know whether you have any reactions, because what he's saying then means that, okay, you say you are injuncting Parliament,
yes,
no problem. The Speaker also comes and says, until the Supreme Court delivers a final verdict on this, we're also adjourning sine die. Do you know what that means?
No, we haven't reached that stage. That's what he claims they intend to do as a reaction to the Supreme Court ruling. We haven't come to that bridge. But you know, when we speak of the Supreme Court, they are made of people like you and me. With due respect, I could have been sitting on the Supreme Court. I'm not there for a reason of my own. So the point of the matter is that I don't become transformed into a superhuman once I go to the Supreme Court.
In other words, Supreme Court justices are also fallible.
That is so. They make errors. So what we're talking about, whether they've made an error in this case or they've not made an error, I'm not making a pronouncement. The matter is still before them. But the legal jurisprudence, the legal regime allows for business to proceed and to continue in spite of any party's feelings about a matter before the court. And so the point I'm making is this, that assuming, you know, I've deliberately refused to go into the merits of the case before the court, because once we go there, the whole thing will degenerate. But being before, we are dealing more with an issue of procedure. And the point is, a person feels disaffected by the way the court has acted. And therefore, and knowing also that citing them for contempt will bring some disorder into the system. On the strength of that and that only, they decide that, okay, we'll ignore you. But the point I've made, which I'll repeat, is the effect of what our parliament or a section of our parliament is doing on the Ghanaian psyche. How many people, apart from Parliament, can exercise that right to disagree and disobey the Supreme Court at the same time? We all disagree. We all, at every point in time, because never ever made, there are all kinds of suspicions. These things are even being run on all party lines and so forth and so on. But the real issue, as I'm concerned, is how we must behave towards decisions of the Supreme Court that we feel is affected with, however, and irrespective of what reasons we have for being disaffected.
You know, the argument...
Is that also to say we should swallow everything? Especially as you start on the trajectory of the fallible, I don't know.
The argument that Dr. Arthur Kennedy made over the weekend is that the Supreme Court appears to be doing more politics than law. And now we can also say that both the NPP and the NDC have made this an issue, or they're framing it as an issue of party dominance in Parliament. The question on my mind is, how can constitutional matters like these be kept from being overly politicized? Because now they're threatening that Parliament, they're going to hang Parliament. That means every business that needs to be in Parliament, there's that LI that needs to be repealed, so many other issues. I know that the NDC is happy because there's that tax waiver bill that they are trying to stop and all that. What do we do? How do we move on from here? Amanda?
I think the Speaker of the House is the leader of his House, and he will inform the Ghanaian population about what he intends to do through, speaking to the members of Parliament tomorrow. And I would be so bold as to predict that should he be asked about whether those vacancies are still available, he will confirm. He's not confirming what the majority is, but he's just confirming what he said stands. He's announcing again that the 4 vacancies are vacant. And then it will be up to the Supreme Court whether they are going to hold him in contempt, and then he can hold them in contempt. And then all the law students throughout Ghana can get a perfect example of why the separation of powers means stay in your own lane.
I think at that point, the students of law and practicing lawyers, do you know what we'll get to do?
Celebrated this example.
Some of us, we like it when the law is tested.
Yes, it's tested.
So we'll get a nice sofa,
yes.
grab our popcorn, and then, we'll watch
what power looks like. What power looks like.
As it unfolds.
Tomorrow is less than 24 hours now, so let's see how it goes. We have to take your final comments.
Maybe we should start with Roxanne,
who is
online, and we'll have to go.
Yes.
That we can come into the studio.
Give us a wrap of your thoughts. We are wrapping up. Do we have...
my final thoughts on this matter is that we should be questioning why a certain political party will allow its members to abandon ship and still insist in Parliament that they remain its members on the floor of Parliament, when the same political party, just 4 years ago, took the same decision to have a member sacked from Parliament when he took the same step. That's one. 2, Speaker has one of 2 options available to him. Either to enter the matter as a party and fight and seek to set aside the decision in this matter, that is if he's minded, or if he's guided by the generality of the application of law, he has to shut down Parliament. Because any further step we take on Tuesday will be to maintain the status quo ante. And before our president went to court, what was the status quo ante? The status quo ante was that the NDC had become majority. So if there's anything to be said, it is the effect that the status quo ante in Parliament must be maintained. And so as for that one, we will insist on it tomorrow.
So in other words, you are defying that injunction to stay...
No, I am saying it's not... you see, the Supreme Court says, stay your hand. It is after the pronouncement of Speaker.
Right.
Anything to be said is ipso facto Speaker's pronouncement before the House. And as soon as Speaker made those pronouncements, there's something we call automaticity of application of law. Once your numbers have been reviewed, you have become a minority. It is as simple as that.
All right.
So before we adjourn on Thursday, it is the NDC that is the majority. And that is all we maintain. So either we do that, or Parliament adjourns in that until the Supreme Court determines the matter.
Thank you so much, Roxanne Nelson Dapemeko, Member of Parliament for South Dai. Let's come back into the studios and wrap up. Mr. Painstil.
I will only quote a scene or saying from Julius Caesar. He said, "O men, O judgment, thou art fled to brutish beasts, and men have lost their reason." That is all.
That's it? You leave it
the
at that?
situation in which we find ourselves, that's the only judgment. Thou art fled to brutish beasts, and men have lost their reason. These are the people we have voted to rule our country. All parliamentarians, I'm not talking about one section, one side of them. They've led us to where we are, and now we don't know whether we are going left or we are going right.
Mr. Painstil,
these arguments are healthy for
do you want to extend that to the executive and the judiciary as well? Because if you look at certain actions, I cited for you the bills that the president refused to sign. I've cited for you other things where the law is clear. Do this. and it's not being done. Do you think we should extend it to them? All our leaders, are they doing what is right to, you know, and have they all lost their reason? I don't know.
You see, I may wish to limit myself to where we find ourselves. Because, see, what goes on in the body politic of Ghana, if we are to go into that, we may need another session to come in and say what we have to say. Because, in fairness, I mean, there's a perception. I mean, you are letting me to go into further details. I mean, there's a perception, for instance, that what's going on has also got politics to do with it. But nobody's talking about it. And that is what is feeding the undercurrent. And we're having all of these things appear on the surface. And somewhere along the line...
Politics from which side, I must...
Both sides. In
well,
other words,
yes, well, it is politics. I thought politics from the judiciary side as well.
Oh, no, the judiciary don't engage in politics. I'm an MPP sympathizer. If I'd gone into the place, somebody would say that I make decisions because I'm an MPP man. The law is very clear. And therefore, I don't accept...
I have a final point for you briefly. You don't have to respond.
Please do.
Our time is up. But the point is, when the judiciary is not beyond politics. When they go there, just as a president, once you get elected, you are no longer NDC, you are no longer MPP, you are no longer from any other party. You are there in the interest of Ghana. The assets of the country are vested in you for certain reasons. But we also know that they remain political and they vote. So, and you can have on the face of the law one line that 5 people will all interpret differently. And sometimes you cannot distinguish whether there's politics in there or
I agree.
Amanda,
in the US.
final words and then we're out of here.
My final words is that the notice of polls confirmed that 4 MPs were running as independent candidates. And no matter how you look at it, Article 97(1)(g) says, if you seek to remain in Parliament as an independent member, meaning you're not NPP, you're not NDC, that means you're independent. That is very express. And so if something has been circumvented in a way where there's a stay of execution on a fresh suit right up to the elections, it is also perhaps for Parliament to express that they are an independent arm of government. And we will see where the chips lie. But honestly, I think this should be tested tomorrow because, you know, they all have equal power in different ways. And that's what separation of power means, checks and balances.
Sweetie,
Yes,
so, you know, this reminds me of a song. Who is majority, who is minority? We used to be majority, we are minority, we are... Come back, come back, come back.
But before it comes back, there was something that was popularly known as the West African wager between Nkrumah and Ofobuani about the future of the politics of their countries. So I'm setting up a wager between me and Amanda. When the Supreme Court eventually sits on this matter.
Benjamin, I'll bring you popcorn tomorrow.
Please bring me some salt and some sugar because it's going to pop.
They'll sit on the matter after the elections, which will make the point moot.
Well, thank you so much for joining us on this. It's been a great panel, really. I've enjoyed myself, and the lawyers came to argue their points out. It was beautiful.
Yeah.
Benjamin,
we had Kweku Pencil, a lawyer. Thank you so much, sir. Amanda Clinton, also a lawyer, passionate about these affairs. And we also had another lawyer who is also the legislator for South Dai, Roxanne Nelson Dafiamekwo. All of them joined us for this conversation. We take a breather. We'll be back with more action talking about Galamsey and other related matters. Stay.